Well, thank you, Bill. I'm pleased to welcome all of you to the Gregorian University Foundation's annual Distinguished Lecture. The purpose of this series is to give our alumni, supporters, and friends access to some of the intellectual riches of the Gregorian University and to show the many ways it serves the Church through its teaching, scholarship, advising, and participation in church governance. This year's lecture, as Bill said, is Crime and Punishment in Catholic Canon Law, Updating the Pursuit of Justice by Reverend Robert Geisinger, S.J., a member of the Canon Law faculty at the Gregorian. Canon law provides the framework around which the Church organizes its institutional and community life, and the Gregorian is widely recognized as the Catholic Church's premier program in canon law because of its depth and rigor and the extensive expertise of its faculty. The graduates go on to be chancellors, bishops, heads of tribunals, advocates, scholars, and teachers all over the world. In this lecture, Father Geisinger will talk about the Church's penal code, which is how it enforces the Church's norms of conduct. This is an important element in the Church's life, but one that is little known or understood by most Catholics. We have been painfully aware of a number of scandals related to the conduct of those with authority in the Church, but hear little about the Church's response, which leads to accusations of indifference or cover-up. In fact, however, the Church has a sophisticated structure and set of procedures for dealing with accusations of misconduct, which it pursues with great vigor. Father Geisinger will explain those procedures and the principles on which they are based, with special emphasis on how they have recently been updated to meet modern expectations of authority, accountability, and transparency. No one is better qualified to speak on this topic. After his early education with the Ursuline sisters, Father Geisinger came under the influence of the Jesuits, first at St. Ignatius High School in Cleveland, then Loyola University, Chicago. He was hooked and joined the Society of Jesus in 1981. While he was studying for the priesthood and discerning about future ministry, the teacher of his canon law course, himself a Gregorian graduate, told him he should go to the Gregorian and study canon law. So he did, from 1990 to 1994, getting his licentiate and doctoral degrees there. He returned to Chicago, where he worked as a canon lawyer until he was called back to Rome in 1998 to join the canon law faculty at the Gregorian. At the same time, he spent 14 years as the procurator, that is, the chief legal counselor for the Society of Jesus. In 2014, Pope Francis appointed him as the promoter of justice in the Congregation for the Doctrine of the Faith, which means that he is in charge of implementing the Church's penal code and overseeing the prosecution of potential violations. One might say that he is the head DA for the Catholic Church. He also continues to teach at the Gregorian, direct theses, pursue scholarly work, and participate in various spiritual ministries. Father Geisinger will speak for about 30 minutes. That will leave about 20 minutes for him to take questions, which I will moderate. You can submit questions by clicking on the Q&A button on your Zoom screen. Please understand that due to the sensitivity of his current position, Father Geisinger cannot discuss specific cases, so we can only take questions about general principles, concepts, and procedures. Now, I'm delighted to turn the proceedings over to Father Robert Geisinger, S.J., the Church's promoter of justice.
I'm looking forward to sharing with you some thoughts on crime and punishment in Catholic canon law, updating the pursuit of justice. So a couple of things to say. First of all, I'm pleased to be here, and I'm grateful, indeed honored, by the Gregorian University Foundation to be with you for the next half hour or so. And there'll be opportunity for discussion and question and answer. Now, there's so much to say in this particular moment, so I'm kind of limiting myself with some care, I hope. This will be a presentation in 3 parts. Following this introduction, a word about what is new. Now, we're talking penal law. We're talking crimes or delicts, as they're known in canon law. The pursuit of the truth, the application of justice that will follow if a crime has been proven in Catholic canon law. Again, I'm speaking exclusively in the ecclesiastical forum here. So what is new in this pontificate? Now, having just said pontificate, we think of Pope Francis, and we pray for him in these days, of course, when he's in Canada. And one of the topics that he's addressing is the past, and as he has said, activity which is to be condemned, and it's not Christian. So we know that we have that deeply in our tradition, the notion of what is wrong, and that's morally wrong, and what is sinful. And then what I'm going to be talking about specifically is that which rises to the level of a delict, that which rises to the level of a crime. Pope Francis has taken this really quite seriously, as we know from the Year of Mercy at the beginning of his pontificate, how much he cares for the notion of mercy, forgiveness, reconciliation, deeply ingrained in this pontificate. But let there be no mistake, also in this pontificate, Pope Francis has generously and zealously been helpful to all of the faithful in some new documentation. And I'm going to be talking specifically about 3 documents within the context of penal law and Catholic canon law. After that, I'd like to spend a moment or two looking at some philosophical and theological foundations, without which we really can't understand Catholic penal law, the pursuit of truth and justice, the application of law, the interpretation of law. This relies on a certain philosophical and theological foundation that I want to be looking at with you. And then thirdly, the third section, we'll be looking at some points of Catholic penal law that perhaps are uniquely Catholic, or if not uniquely Catholic, there's a Catholic spin to it, deep in our tradition. And those will be some fairly concrete points. Now, of course, this is a fairly cursory presentation because we don't have much time for it. So perhaps this can be more an impetus for further reflection, points of reflection. This is, as I said, about penal law, crimes, punishment, to put it kind of in the Dostoevskian motif. This is not about moral distinctions. This is not about Christian ethics, right? I'm speaking now as a canon lawyer about penal law, penalties. So let's talk about what is new in this pontificate. That will be the first of the 3 groupings that I'd like to address with you. So the 3, and I'll explain what I mean by these, will be the revision of Book 6 in the Code of Canon Law, Vos estis lux mundi, which is the Latin phrase for you are the light of the world, and then the last revision under Pope Francis of Sacramentum Sanctitatis Tutela, for the care of the sanctity of the sacraments. That would be in English. These are 3 documents, and just in the last few years from Pope Francis that are really quite important. So what's new in the pursuit of justice and in the adjudication of crimes, or delicts, as we say canonically, delicts? Again, we have sins in the moral order, but not all sins rise to the level of being a canonical delict. So when I say Book 6, I'm talking about the Code of Canon Law, the Code of Canon Law for the Latin Church. Now, we have 2 primary codes of canon law in the Church. One is for the Latin Church, and the other would be for the 22-23 sui juris churches of the Eastern Communion, Catholic churches of the Byzantine tradition, the Syro tradition, the Armenian tradition, right? The Code of Canons for the Eastern churches, and then the Code of Canon Law for the Latin Church. both of which have sections on penalties. Right? Now, in looking at the revision of Book 6, I'm speaking of the Latin Code for the Latin Church. Book 6 of many books in the Code of Canon Law is the book that deals with censures, sanctions, and penalties. Now, Pope John Paul II, St. John Paul II, in 1983, following the Second Vatican Council, and it was already envisioned, of course, by Paul VI, that there would be a new Code of Canon Law necessary, and that was promulgated in 1983 by the successor of his successor, Pope John Paul II. 1983, our knowledge and awareness of what is wrong in the moral realm, well, maybe that's developed and changed and whatnot, but certainly our sense of what constitutes a crime has developed. Book 6 needed to be looked at with care and precision. In a long process of a good 10 years, effectively this pontificate, it was necessary to dig in to see what needed to be abrogated, that is to say abolished, what needed to be brought in because of what we have learned about delicts, crimes, and the necessary punishments that will follow if somebody has committed such a crime. So this we're talking about the Book 6, the document Pascite Regiam Dei, which promulgated the revision of Book 6 from 1983, now in 2021, at the end of 2021, 23 May, it was promulgated, it was put into effect, Feast of the Immaculate Conception of 2021. And this is how Francis wrote that particular introduction. Tend the flock of God. He's speaking primarily to his brother bishops, right? As Bishop of Rome, as the legislator. Tend the flock of God that is your charge, not by constraint, but willingly, as God would have you. There he's quoting the first letter of Peter, chapter 5, verse 2. Continues Francis. In her earthly pilgrimage, the church has established from apostolic times, so from the apostles, right? Laws and rules of rules of conduct that down through the centuries took shape as a cohesive body of binding norms, corpus juris canonici, corpus, a body of binding norms, safeguarding the unity of God's people. So important in this pontificate, right? The unity of God's people. Founded upon that faith, they manifest the maternal mercy of the church, which is ever concerned for the salvation of souls, right? When we're punishing because it is just, but we're always concerned about the salvation of souls. Amid today's rapid social changes, it has become clear that a fitting response to the needs of the church throughout the world calls for a revision of the penal discipline in the Code of Canon Law promulgated by St. John Paul II on 25 January 1983. So that the church's pastors, leadership, bishops, major superiors, religious, can employ it as a more flexible means of correction and salvation, capable of being applied swiftly. Justice delayed is justice denied. The wheels do turn slowly, though. Capable of being applied swiftly and with pastoral charity in order to avoid more serious evils and to bring healing to injuries caused by human weakness. So that's his introduction to the revision. Now let's just take a look at the structure so you have some sense of what I'm talking about, this famous new Book 6. These are just the titles to show you how it's divided. The punishment of offenses in general, it's kind of a section of kind of general norms as to how we deal with the notion of punishment. Those who are liable to penal sanctions, right? Who the Catholic Church can punish if you've done this crime, this canonical delict, who can be punished? Censures, expiatory penalties. Now, I'll mention a little bit more about what a censure is and what an expiatory penalty is. Briefly, a censure is medicinal, remedial. I want you to change. I, as competent authority, I am telling you that what you have done is wrong. This is a sanction. Once you have corrected it, Once you have remediated the situation, the medicine has worked, the situation has been healed, right? Expiatory penalty, it's not necessarily about remediating the situation. The situation is what it is. But justice demands that a penalty be imposed. Justice demands that a penalty be imposed. So that's a separate section in Book 6. The application of penalties, how they are applied, the remission of penalties, the lifting of them, the taking away of them. Offenses, again, now here we get into specific concrete categories of types of crimes in the Catholic Church. Now, much of this is well in the tradition, so not all of this is new with Francis. How it is organized and the tenor of a good bit of it is new. Offenses against the faith and the unity of the church, offenses against church authorities and the exercise of duties, offenses against the sacraments, I'll have more to say about these later, offenses against reputation and the offense of falsehood, calumny, offenses against special obligations, and offenses against human life, human dignity, and human liberty. It's kind of a sense of how the Book 6 is organized. So again, that was revised, went into effect Feast of the Immaculate Conception, 8 December 2021. That's the first of the three documents that I want to mention. From the summer of 2019, 3 years ago, Pope Francis promulgated Vos Estis Lux Mundi. Vos Estis Lux Mundi, you are the light of the world. This was dealing with a lacuna, a hole in canon law that was not really in Book 6. It was touched upon, right? So as a kind of an immediate remedy, as an immediate solution, we have Vos Estis Lux Mundi, you are the light of the world, speaking specifically to competent authority, speaking specifically to bishops and religious major superiors. A key notion here is negligence, covering up. You knew of a canonical delict, by way of example, the most obvious. A delict committed by a cleric against the sixth commandment with a minor, among the most serious delicts and crimes that we have, right? If an ordinary knew about this or knows about it, and either chooses consciously not to react to it, that becomes a canonical delict. Or maybe is simply ignorant, but it's a culpable ignorance. That can be equated with negligence, right? You should have known and you didn't know and you didn't act. Vos Estis Lux Mundi wants to do away with silence that hurts, silence that damages. When competent authority, the authority in charge, a bishop, a religious major superior, doesn't act. So again, you are the light of the world. That's from 3 years ago, and that's currently under revision. And then the third document in this first section that I want to talk about, again, hoping that you might find all of this is available in English on the Vatican website, right? Easily found. So the new Book 6 of the Code of Canon Law, Vos Estis Lux Mundi. And now I want to speak for a moment about the revision of Sacramentum Sanctitatis Tutela, the care for the sanctity of the sacraments. Pope John Paul II in 2001 recognized the need to clarify what are called the graviora delicta, or the delicta reservata, those reserved crimes that are considered so serious. Among all of the crimes that we find in Book 6 of the Code of Canon Law, there are some that are so egregious, right, that they are confined, not confined, but they are the exclusive competence belongs to the dicastery for the Congregation of the Doctrine of the Faith. Now, do remember, the Congregation for the Doctrine of the Faith was headed by Cardinal Joseph Ratzinger, later to become Benedict XVI. So he was on the ground floor in 2001 when John Paul II promulgated the first version of the substantive and procedural norms of Sacramentum Sanctitatis Tutela for the care of the sanctity of the sacraments. 2001. And what are these particular crimes? We have Article 2 that deals with apostasy, heresy, and schism. Probably the most common of which is schism. when somebody knowingly removes herself or himself from communion of the Catholic Church and union with competent authority, with the bishop and with the Supreme Pontiff. Article 3 would be crimes against the most holy sacrament of the Eucharist, desecration of the sacred species, by way of example. Article 4, crimes, delicts against the sacrament of reconciliation, violation of the confessional seal, among the most serious delicts that a priest can commit, when something that is said under the seal of confession is repeated, either directly or indirectly. Solicitation in the confessional situation on the act, pretext, or occasion of hearing a confession that the priest, or it couldn't be a bishop, right, who is hearing the confession solicits sinful activity against the Sixth Commandment. Absolution of an accomplice in the Sixth Commandment in the same line. Article 6 takes us to the abuse of minors, that horrible reality that we've been living through and adjudicating all these years, or those who are equivalent. So minors under the age of 18, those who are equivalent to them in law. These are the reserved delicts to the dicastery for the doctrine of the faith. This was clarified by Pope John Paul II in 2001. 2010, now Benedict XVI, former prefect of the Congregation for the Doctrine of the Faith, revises the substantive and procedural norms. I don't have time to go into the distinction. Perhaps some of the lawyers, even canon lawyers, well understand the substantive norms, what constitutes the itness of it, and the procedural norms, how to proceed. 2010 revised, and December 8th of 2021. At the same time that the new Book 6 is coming into effect, the revision of the substantive and procedural norms. This is basically to bring into law, bring into the substantive and procedural norms, developments since 2010. I don't have time to go into exactly what those are, but these are three key documents when we're looking at what is new in recent years, particularly in this pontificate, when we're talking about penal law and the application of justice. Now, I'd like to turn to the second point, and this would be the foundation. When we're adjudicating a delict, before we get to the process whereby we need to gather the witnesses and proceed with the process and assess the truth, even before we get there, what is the notion? What is the conceptual foundation? I'd like to point to two canons. Now, mind you, we're always with cum Petro e sub Petro. We're always with Peter. We're always with the successor of Peter, the vicar of Christ, the legislator, as we canonists call him, the legislator. But today's legislator, I just mentioned today's legislator, Francis, and three documents that are significant in terms of the application of penal law. We go all the way back to Scripture when we look for our foundations. For instance, we have seeds already in the gospel, in the Acts of the Apostles, in the early councils, how the developing Christian community dealt with crimes within the community, delicts within the community. They were adjudicated. We even have from the mouth of Jesus himself in Matthew 15, verse 18. If your brother sins against you, go and tell him his fault between you and him alone. If he listens to you, you have gained your brother. Unity, yeah? Reconciliation. But if he does not listen, take one or two others along with you, that every word may be confirmed by the evidence of two or three witnesses. If he refuses to listen to them, tell it to the church. And if he refuses to listen even to the church, let him be to you as a Gentile and a tax collector. We have to contextualize that. Truly I say to you, whatever you bind on earth shall be bound in heaven, and whatever you loose on earth shall be loosed in heaven. We associate those words, don't we, with the sacrament of reconciliation. Now, let's come contemporarily. So I would like to go to the two codes. Now, the Code of Canon Law for the Latin Church, first from 1917, as I said a couple of times now, 1983, St. John Paul II, following the Second Vatican Council. And then the Code of Canons for the Eastern Churches, 1990, which I've mentioned. I'd like to begin with the Code of Canons for the Eastern Churches, Canon 1401. This is simply magnificent. The genesis of this canon goes back centuries. Canon 1401. This is how we approach penal law. Since God employs, this is a canon, so this is a code of canons. Since God employs every means to bring back the erring sheep, those who have received from him the power of loosing and binding, we just saw that in Matthew 18, right? The power of loosing and binding are to treat appropriately the illness of those who have committed offenses by correcting, reproving, appealing, constantly teaching, and never losing patience. Aha, when that doesn't work, and are even to impose penalties in order to ensure that the wounds inflicted by the offense may receive a cure, and to preclude the offender from being given to dissoluteness of life and contempt of the law, that he continues outside the realm and continues in a damaging way. The lost peccare, to bring back the lost sheep, to bring back the lost sheep by correction. But let there be no mistake. Penalties will be applied if he is contumax, as we say, if he's persistent, if he's incorrigible, if he's uncorrectable. Now we have two canons. We have the one in the Latin code down. I'm coming over to the Latin code I'm leaving the Eastern churches. We have two versions, which I'd like to point out to you because there's a lovely nuance, and I think an important nuance to show, again, the mentality as it is developing. This is the 1983 version, of Canon 1341, Code of Canon Law. An ordinary, again, that's a bishop or religious major superior, competent authority, the one in charge. An ordinary is to take care to initiate a judicial or administrative process. There's a distinction there. A judicial process is a trial. An administrative process is like an abbreviated trial. An ordinary is to take care to initiate a judicial or administrative process to impose or declare penalties only after he has ascertained that fraternal correction or rebuke or other means of pastoral solicitude cannot sufficiently repair the scandal, restore justice, reform the offender. Notice the order there. Repair the scandal, restore justice, reform the offender. In the new Book 6, promulgated at the end last year and then put into effect on the Feast of the Immaculate Conception of 2021, the ordinary must start a judicial or administrative procedure for the imposition or declaration of penalties when he perceives that neither the methods of pastoral care, especially fraternal correction or by warning of correction, can justice be sufficiently restored, the offender reformed, and the scandal repaired. There are two things here at the philosophical and in some ways theological and quite concrete foundation level that I'd like to point out here. 1983, he is to take care. 2021, he must start a process to adjudicate. Only if, now we have the fraternal correction, if these other things don't work, then he must. Now it's the ordering though. In 1341, why do we do this? 1983, repair the scandal, restore justice, reform the offender. 2021, justice be sufficiently restored, the offender reformed, and the scandal repaired. Scandal, which is very significant, is the third in line. Let no one take as an excuse, well, what about the scandal? We can't deal with this. What about the scandal? That's no longer an excuse. It's in the mix, but the scandal be repaired, acknowledging the scandal that's happened. But what's most important, what has been moved to first place is justice be sufficiently restored. the pursuit of justice. Now, prior to that, we have the pursuit of truth. What is true? And in proper interpretation and application of law in Book 6, what's the just punishment if the person is guilty? Okay. That's what I have to say about some of the foundation. So we have the newness of Book 6, Vos Estis Lux Mundi, the procedural substantive norms of Sacramentum Sanctitatis Tutela. We're talking about this progression from 1983, but in this pontificate, we're looking largely at the last 3 years. The movement forward in acknowledging current realities with the difficulties that the church has been dealing with in the realm of delicts, and again, most notably, Article 6 of Sacramentum Sanctitatis Tutela that I mentioned before, and that would be the abuse issues and the reserved delicts. Now, I have about 10 minutes or so remaining. I'd like to look at some themes and issues, many with a peculiarly or particularly Catholic twist. Now, a crime we call a delict. In the earlier language, it was a crimen. We have in the Catholic Church, in the Latin code, but not in the Eastern churches, automatic penalties. Automatic penalties. If you do this ipso facto, by the fact itself, ipso iure, arising from the law itself, you do this arising from the law, the penalty is applied. That's called late sententiae, means automatic. So if you commit a schismatic act, by way of example, I mentioned before, if you remove yourself knowingly and other criteria are fulfilled, that you commit the delict of schism, late sententiae, you are excommunicated. That's the most commonly known late sententiae penalty. Eastern churches don't have that. The Byzantine family, the Syro family don't have automatic penalties. Also, this distinction that we find in canon law, I mentioned it before, now I want to mention it again. Censures, which are medicinal penalties, medicine, bring the person back, heal the situation. Once the person comes back, by way of example, that schismatic, once that schismatic returns to the communion of the church, wants to have the penalty lifted, the medicine has worked. The remediating call, the invocation, come back, at the convocation, return, the person does. There are a couple of canons that says the person has a right. In fact, that penalty must be lifted, as opposed to expiatory penalties. Expiatory penalties that justice demands. It's distinct. It's not that we don't care about the reform of the offender. We certainly do. And the medicinal quality, the healing. But we're a little bit more concerned about the healing of the community and the healing of those who have been harmed, right? Justice demands expiation. So even if you're repentant, forgiveness needs to be discussed clearly. But justice demands the imposition of a penalty. By way of example, loss of the clerical state. For a cleric, for a deacon, priest, bishop, former cardinals, whatever, loss of the clerical state, whereby you lose your clerical identity. You cannot be called father or reverend. You cannot dress as a cleric. You cannot be buried as you lose all the rights as well as the obligations of being a cleric, except for the obligation of celibacy. But that's a separate matter, right? But justice demands expiation. This is imposed. Okay, so medicinal penalties, expiatory penalties. We've already seen in canons 1401 and 1341, in Catholic penal proceeding or procedures going forward, before going forward with penalties, admonitions, warnings, rebukes, precepts, that the person must be warned before a penalty is imposed, before a process is begun. Come back, stop that. What you're doing is wrong. What you're doing is delictual. It's possibly criminal, right? We try to remediate the situation already up front. Another notion that is a little bit peculiar in our tradition, and it's deep and it's marvelous. No penalty as such without a process. Now, I mentioned the lati sententiae ipso facto. Okay, that's a separate category. Accepting that, other than that, no penalty without a process. That I have a right, I as the accused party, presumed innocent, with an advocate to help me in working through the technicalities of this, I have a right to have this adjudicated in according to the norm of law, as we say, before the penalty is imposed. The Catholic notion of moral certitude in the application of penalty. So you have to be guilty. And we have to arrive at that notion of guilt, that certitude of guilt, moral certitude. It's not beyond a reasonable doubt, but it's like that. It most certainly is not a gut feeling. It is not an intuition. It is not what might be, or she or he looks kind of shady to me. We say in canon law, ex actis et probatis, from the acts and the proofs. The moral certitude of guilt arises. Now, it may be that 3 judges on a tribunal might not agree that moral certitude has been reached. But arising from the acts and arising from the proofs, we know with moral certitude, for us in the Catholic tradition, most recently, the great clarifier of this was Pope Pius XII. Pope Pius XII wrote on this. Another peculiarity, retroactivity. The more favorable law, if law changes, so I've mentioned the new Book 6 and the new procedural and substantive norms of Sacramentum Sanctitatis Tutela. If the legislator, if the Holy Father promulgates a new law that changes the imposition of a penalty or the notion of what has gone wrong here, how the community has been offended by this offender, the more favorable law is to be applied. The right of defense and the presumption of innocence. This is made more explicit in the new Book 6. The presumption of innocence, that is so difficult in our internet-driven world right now. The staining of a person's good name, or maybe not so good name. But what has not been proven has not been proven. And indeed, the Code of Canon Law allows that false accusations can be prosecuted ecclesiastically. It's right in the code, but maybe not as fully executed as it could be. I've mentioned the remission of censures, that the notion of especially a medicinal censure, that first category that I mentioned, when the offender is healed, the penalty is lifted. In the Catholic Church, we have this wonderful meeting of centralization under the legislator, on this earth, the supreme judge, who is the supreme pontiff, right? Centralization while respecting and needing subsidiarity. Delicts that are adjudicated on the local level. So if there is a problem with temporal goods, if there is a problem with stealing on the part of a pastor, stealing funds from his parish, that this is dealt with on the local level, and then at the levels of appeal or recourse, those are 2 different types that we don't have time to go into, but that one then goes up the chain, the centralization. I mentioned before the notion of reserved delicts. We're not talking about reserved sins here. That's a prior concept, but that there are certain delicts that can be reserved to the Holy See. I mentioned a moment ago those under Sacramentum Sanctitatis Tutela that are reserved to the congregation, now dicastery, for the doctrine of the faith. And the last point that I'd like to mention, the challenge of knowing mercy. When someone has been hurt, a crime has been committed, the community is involved, a person, persons, I mentioned a moment ago, a parish community. Justice demands, if guilty, that the guilty party be punished. Justice can't but be balanced with mercy. Mercy it's driven by the Spirit. Mercy is based in grace. Justice is based in truth. Justice is based in the proper interpretation. This too is a grace process when the guilty is punished for what he or she has done. Mercy is the movement of how the prodigal son is received. Judge and doctor, that we have to adjudicate, but we also have to assess what medicine is needed. True in adjudicating offenses and meting out proper and just punishment for the welfare of the offended, the ecclesial community, and the offender. Let there be no mistake about it. The offended, those who have been hurt, the need for justice there is real. Closing, 2 points, challenges for the near future and beyond. Authority, accountability, and transparency. There have been some fine steps in the last 20 years, in the last 10 years, in the last 5 years, in the last 3 years. Good steps forward, authority, accountability, transparency. We have farther to go. True victims' rights, participation in the process of adjudication of a delict and the damages, which is really very different. In so many cultures, so many countries, the notion of damages is developed and it's clear what may be applied by way of damages. Not so clear in canon law. These are two challenges. So in conclusion, right? Jesus Christ is Lord. He founded the church. The bark is not going to sink. The navigator since 2013 is Francis. Jesus Christ, our Lord, ever and always the voice of mercy, spoke about crime and punishment, Gehenna, with remarkable clarity across the Gospels. Though we tend to either ignore that language or look to it more when convenient than not. Jesus conquered sin. He already has redeemed all of our wrongs through redemption. But this does not mean that the last judgment is not true and that we don't already have a taste of it here on earth when we need to adjudicate delicts, canonical crimes. However feeble our improvements have been in the application appropriately of canon law is clear. I believe in these institutional means to get to the truth across cultures, across difficulties that to our Lord were not unknown, and to serve that truth and the justice that follows. Our Lord demands this of his church. I hope we're getting better at it. I believe that we are. This pursuit is my passion, and in the Sacred Heart of Christ, my love and my hope. I thank you and the Gregorian University Foundation for this opportunity to speak a little bit about the updating, the pursuit of justice, and where we are as the Catholic Church, again, seeking truth in Christ, in mercy and love, seeking truth and the proper application of justice that follows for those who are guilty of canonical offenses. Thank you.
Father Geisinger, you're terrific. Thank you. But you are a lawyer and I'm not. And yeah, I wish I was one of your students. It would take me a few classes to catch all this. You covered an awful lot of ground, Father, and I can't thank you enough for it. You're really wonderful. I am, I'm not a lawyer, okay? I'm a fundraiser by trade, one of those rare Jesuits. And I got a couple of interesting questions. Who is the judge in these circumstances?
Well, it depends on what circumstances we're talking about. In a usual situation, and I'm not talking about a reserved delict here, I'm talking about something that can be handled on the diocesan level. Let's take the average diocese. The highest judge in that diocese is the bishop. The bishop usually has a judicial vicar, someone to whom, arising from the office, has a certain authority. When a judicial process, when a trial is created, 3 judges are named by that judicial vicar. So those are the judges. They need not be priests, right? But in a trial, they must have at least a licentiate, the 3 judges.
And then I have a visual imagination. Okay. So when I think of, I've been in courtrooms and I've seen the trials, I've been in court, the judge, the jury, the lawyers, defense, and whatever. How can I visualize what happens when a person is accused of a really canonical crime in the church? What does it look like?
It doesn't look like a Perry Mason set. It doesn't look that way. Ex actis et probatis, right? So much of work that there are 2 exceptions to that. One is the taking of testimony. The taking of testimony is clearly and unambiguously and importantly an important human moment where the interrogation takes place, where there is a back and forth. The second moment is when a decision is reached. And those in what we call an administrative process, so the delegate who is overseeing the process with 2 assessors, or in a judicial process, a trial with the 3 judges, or in some circumstances, 5 judges, right? That conversation is it's a collegial moment and an important moment. But the notion of folks coming together in a room, in an aula, day after day, that is not quite how the procedures tend to run. Much of this can be accumulated in a documentary fashion. There is a significant distinction between a trial and an administrative process that, again, that would take a whole class to explain. A trial demands more in-person activity, but in neither situation do we quite have the Perry Mason motif.
Before I turn this over to our chairman, Mr. Whalen, to ask a few questions, the church is not known for doing something speedy.
Yeah.
And as you said earlier on, justice delayed is justice denied. If someone's accused of something, how does the church really make sure that it moves as quickly as possible?
Okay, so now I'll speak.
You sound very Italian.
No, this is what I have experienced as promoter of justice at the dicastery for the doctrine of the faith. So when I came into the office 8 years ago, and also for my predecessors, this was clearly an issue. But it's become really an issue because for us to deal with what are known as the most grave delicts that I mentioned before, with Sacramentorum Sanctitatis Tutela, sins against the sacrament of reconciliation, against the Eucharist, and especially against the morals concerning young people and those who have habitually the imperfect use of reason. The backlog was there because we didn't have the staff. The Holy Father has been generous in saying the money is there to pay for the canon lawyers if you find them. But the lack of staff, now what we do, you mentioned before, who's the judge, as we would then delegate, we at Congregation for Doctrine of the Faith, now dicastery for the Doctrine of the Faith, as we would delegate this out to the local level, they have to have the canonical resources, right? And so Paraguay is not the United States, is not Tanzania, is not Austria. Different places have different staffing possibilities. That's one issue. Cultural norms. The Far East, Indonesia, is not the UK when it comes to how one works through eliciting the evidence and eliciting the information that we need from accusers, right? So lack of personnel, the cultural norms, the quantity of cases. Again, I'm just speaking about my little corner of the world, which concerns the reserved delicts to those that are reserved to the dicastery of the Doctrine of the Faith. Yeah, it's a real issue, and it's a weight for those who are involved in these processes. And at the local level, there was yet one more feature that we can't deny. It's COVID. And how that slowed the progression of cases that needed to be adjudicated around the world. When, as I mentioned before, people need to be together, judges need to be together, witnesses need to be heard. And then a canonical question then became, how much can we do by Zoom or not do by Zoom? So those are all issues. Heck.
Thank you.
Father Geisinger, thank you so much for helping us this evening. You've given us some views on you've updated us on the pursuit of justice. Where are we in 5 or 10 years from now? What's the future of canon law pursuing justice? Oh,
that's a marvelous question. And the answer is, I don't know. I mentioned 2 areas that I would hope that we can get a handle on, but they are so complex. The number one is access to the process and transparency. The world has so moved, years ago, the world moved in this direction. But how we get there, because we also have church-state relations that can be involved here, and who has access to what. And again, participation in the process, especially those, the advocacy of accusers, not just accusers, who might or might not be true victims, but those who indeed are true victims, right? These are challenges that exist. There's no going back, right? So the reforms that have been happening in the last 5 to 10 years, we have a new book in the Code of Canon Law, a whole book that you can't undo that. The Supreme Legislator, Pope Francis, has done this. There's no going back. That much we know. Attitudinally, the challenges of going forward, as I mentioned before, with cultural norms being what they are, is just one example. Yeah, so where are we in 5 to 10 years? I don't know, but there's every reason to be hopeful that we're going to be better at adjudicating these matters than we are today, because hope is based in Jesus Christ, and Jesus Christ has founded the church, and he's guiding it through the Vicar of Christ. Our current legislator is Francis. So I'm hopeful.
Can I ask you one more question, Father?
Sure.
This is from one of the people who was attending, and so it's what happens if the criminal act is also a crime under civil law, like, for example, theft?
Oh my goodness. Cooperation. Now, this is clearly in vos estis lux mundi, right? But in general, CDF was speaking to this already 11 years ago. Cooperation with the state is that's necessary. That's necessary. Now, what is the state and where are we in the world? Got to be careful. But right now, just speaking from the perspective of the United States, when an accusation comes in, if there are civil implications, the default drive is to see what happens in the civil arena, lest ecclesiastical authorities, church authorities, be accused of tampering or getting in an unhelpful way. Cooperation is a must. Cooperation is a must. And by the way, there are situations in which state authorities can be immensely helpful. One that I would use by way of example would be internet images of minors, pornographic images of minors, where with the technology available to the state, and they can assess, who has been in possession of what, but what are we looking at and what are the ages and what constitutes a minor, that the technology capabilities, that material can then be brought into an ecclesiastical proceeding. So the notion of hiding from civil authorities, again, I'll speak primarily in the Anglophone world, that is now just a must. The cooperation is, and the consequences are what they are. So if somebody's going to go to prison, if a cleric is going to go to prison, the cleric's going to go to prison. And then ecclesiastically, or at the same time, either in a parallel manner or one after the other, civil, criminal, and then ecclesiastical, it will be adjudicated.
Thanks to Father Geisinger for his very clear, engaging, and informative talk, and to all of you who have joined us. Tonight, you have seen one example of the intellectual and spiritual brilliance that is so much a part of the life of the Gregorian University, and how it is put at the service of our church. To see more, follow our newsletters, social media posts, and other communications from the Gregorian University Foundation. I hope that this experience will inspire you to join our efforts to build a more faithful, compassionate, and responsive church by supporting our fundraising at the Gregorian University Foundation, which directly supports the Gregorian University and its allied Jesuit institutions in Rome. Thank you and good night.